My name is Gladys Harden. I'm the Vice President of the local Missoula League of Women Voters. And this forum is co-sponsored by the League and the University of Montana School of Law. And the president of the League is downstairs directing people how to get here. Her name is I was just making sure she wasn't here. Arlene Brown is our president, and also the co-sponsor from the law school. They have been very helpful with helping us to arrange speakers and get publicity and so on. And I think Dean Ed Eck is going to show up at some point, but he isn't here right now. So if they do come, I will point them out to you. But thanks to both of those groups for helping us to do this forum. The funding comes from the League of Women Voters of the United States Education Fund and from the Constitutional and Legal Policy Program of the Open Society. And we would like to thank both of those groups also for providing us with a little bit of money so that we can afford to do these programs. The forum is being filmed for rebroadcast by MCAT under their Media Assistance Grants Project for Nonprofit Organizations, and you may be able to watch the whole program again on Channel 13 if you are interested. This forum and the one following on May 2nd are both eligible for continuing legal education credits, 2 credits for each session if you happen to be an attorney and you need those CLE credits. There is a table at the door with pens, programs for the sessions, and some other materials. If you received the little brochure that told you about the programs, there was a very short excerpt from a paper about courts called Courts Are Different. The whole article is out on the table. If you're interested, pick up a copy. It's quite interesting reading. Our format tonight is going to be pretty simple. I'm going to introduce our judges. They will each have about 15 minutes. Then we will take a very, very short break, about 5 minutes. And then we will go into some questions. I have some questions that we have pre-approved. None of them are too hard, I think. And then we will have questions available from you people in the audience. If you have questions, I would ask you to raise your hand, and we will bring the mic to you so that we can get your question on the tape for MCAT, and also so that everyone in the audience can hear you. So I'll remind you of that when we get to the question part. We have 4 judges with us this evening. I would like to thank them all briefly for being with us. And I'm going to tell you just a little bit about them, although their short bios are in the program. They're very short because I cut them down to make them fit in there. For first judge is the Honorable Donald W. Malloy. He is the Chief Judge for the U.S. District Court based here in Missoula. He was nominated by Senator Baucus and appointed by President Clinton. He was sworn in as U.S. District Judge in 1996 after practicing law in Billings for some number of years. He became Chief Judge in January of 2001. He earned his law degree with high honors from the University of Montana, and then was law clerk for U.S. District Court Judge James Batten. He's received numerous awards and honors, including Montana Trial Lawyers Association Trial Lawyer of the Year. He is past president of the Montana Trial Lawyers Association. He's a former U.S. Navy lieutenant, where he flew the F-4B Phantom from the decks of the USS John Kennedy. He served as a member of the Montana Bar Association Ethics Committee, is also a member of the American Board of Trial Advocates, and I liked his last comment. He played football at the University of Montana from 1964 to 67, and he notes that was a period during which the Grizzlies never beat the Bobcats. Our next judge is Justice Jim Rice, who is Associate Justice of the Montana Supreme Court. Jim grew up in Glasgow, graduated from MSU in Bozeman and the University of Montana School of Law. During law school, he interned with the Missoula City Attorney and the Lewis and Clark County Attorney and was public defender for Lewis and Clark County for 4 years. He practiced as a partner in the firm of Jackson and Rice in Helena, was then elected to 3 terms in the Montana House of Representatives, and served as chairman of the State Board of Personnel Appeals. In March 2001, he was appointed Associate Justice of the Montana Supreme Court by Governor Judy Martz and was confirmed by a unanimous vote of the state Senate. He and his wife have 3 children and 2 grandchildren, and one of his daughters is with him tonight. Judge McLean graduated from the University of Montana in 1969 with a Bachelor of Science degree in business with a major in accounting, and in 1973 he received his law degree from the U of M. Ed went to work for the Missoula County Attorney's Office, where he prosecuted criminal cases until he was appointed to the district court bench in 1989 by Governor Ted Schwinden. He has been reelected to the bench 3 times and is presently running for another 6-year term. He is past president of the Montana Judges Association, a member of the District Court Council, and the chairman of the Judicial Standards Commission, and was previously chairman of the Montana Criminal Jury Instruction Committee. And finally, down there at the very end, Judge Karen Orzik is one of 2 justices of the peace that serve Missoula County. She is in her 2nd term of office, was elected in November 1998 and re-elected in 2002, and is currently running for her 3rd term. She currently serves on the Montana Supreme Court Commission on Judicial Ethics and was reappointed for a 3rd term of service to the Montana Supreme Court Commission on Technology. She is the Montana Magistrates Association training judge for Western Montana and the chairman of the Montana Magistrates Association for District 1. Her formal education is in the sciences, and she has taught at the University of Montana. She has done a number of presentations, some of you may have heard her before, including Montana law, judicial philosophy, and restorative justice. Her background and commitment to the community and nearly 8 years of experience as Justice of the Peace brings us an educated and thoughtful perspective on the role of the Justice of the Peace in Missoula County. And now you know who these people are. I'm going to just pass the microphone on to Judge Malloy, and he's going to tell you a little bit about the Federal U.S. District Court.
Thank you, Gladys. Thank you for having us here, and it's an honor to be here with these other judges. When you were doing the biography, I've worked with the same administrative assistant for 20 years. And I told her the last time she did that about putting the Grizzlies and the Bobcats in there, if she did it again, she'd be looking for a new career. But it also reminds me of how history repeats itself. So, Jim, you're probably happy that the Grizzlies have lost the last couple of years, but Gladys asked us to tell you a little bit about how you, what the qualifications are, how you're selected, and then any limitations on activities as a federal judge or jurisdictional issues. And so let me talk a little bit about the question of qualification. Interestingly enough, under Article 3 of the Constitution, unlike the other articles, there really are no specific qualifications for a federal judge. And in our history, if you look at, there are many different kinds of federal judges. There are, of course, the Supreme Court justices, the courts of appeal judges, the district court judges, the magistrate judges, and then the bankruptcy judges. That sort of is the panoply of the cast of characters in the federal judiciary. There have been a number of people who have been on the United States Supreme Court who were never lawyers. They were doctors or business people. And it's, of course, in the 19th century is when most of that occurred. Currently, we've all listened and paid attention to the selection of Chief Justice Roberts and then Justice Alito. And I don't know if you've tracked those hearings, but they were very interesting and touched on the qualifications. There seems to be now more of an ideological issue than there has been in the past. The process of getting selected is the same technically whether you're on the United States Supreme Court or a district court judge or on the Court of Appeals. The political aspects of it, there's, I think, perhaps much greater evaluation when they're looking for a justice for the Supreme Court. But what happens is that the president, whatever the judge, whatever level, will submit a name for vetting purposes, and that is all goes on behind the scenes. That if your name is submitted, they vet at the White House, and they will vet. When I went through the process with the Bar Association, just as a preliminary matter, and they will do a preliminary vetting with the law enforcement authorities, run those kinds of background checks just to make sure that there's nothing embarrassing to the president or to the person, the senator, who is, might be supporting either a district court or a Court of Appeals judge. The Court of Appeals and the district court judges, generally the way it works, although the White House is much more involved with the Court of Appeals than they are for the district court, they are involved at all levels. And generally what happens is that the senior senator of the president's party comes up with a name either for the district court or a recommendation of the name for the particular seat on any Court of Appeals. That is politically dealt with in the Senate, and then once they go through this vetting process, then the formal process begins. And there is an effort to get every single thing you have ever participated in your life. It's really quite a process. When I went through the process, I had to gather things that, I mean, there were, and do it very shortly. And it was extraordinary, the detail that they wanted to have. Every case you had been involved in, any appellate issues that you'd been involved in, lawyers that you'd dealt with, anything that you had written. And then all of those things are compiled, and then there's about a 25 or 30-page questionnaire, a preliminary questionnaire from the Senate. And so that all gets turned around in a very short period of time, and that just is the beginning of the process. Then the next step is it goes through the White House vetting process again, and then after that, the name can be formally submitted to the president by the senior senator of the president's party. And if there isn't a senator from the president's party, then it would be the senior congressional person who has the principal say in who gets the nomination. So then what happens is they go through the whole process. They read every case you were ever involved in and ask you questions about it, and then they know far more about what you did in your life than you do. It really is an extraordinary process. And then the next step is, after you've been through the entire process, been vetted, and then actually investigated by the American Bar Association, investigated by the FBI, the IRS, the Senate, and then the White House is still doing their own investigation, then it becomes a political issue. You can't go any place unless you get a hearing in front of the Judiciary Committee. And timing, as they say, is everything. And so if you happen to hit in a political year, you might be lucky and you might not be lucky. And some people have gone, I've known judges now who had their names in for 4 or 5 years before they ever got through the process. They had to go through it twice. I happened, Senator Baucus and Senator Burns were both very helpful when I had my name submitted. And the interestingly enough, the White House, the Clinton White House, made a calculated political decision in January of 1996. Senator Dole had been criticizing the president for appointing liberal judges. And so the White House just said, okay, we'll come back at him. And the line they came back with is, if Senator Dole thinks these people are so liberal and so bad, the president submitted 181 names and he's voted for 180. So what's the problem? Well, Senator Dole said, you're right, and that stopped all the hearings, and it just ground everything to a halt. Fortunately for me, Senator Baucus, the Democratic Party was working very closely with Senator Hatch, and so the process goes through. You have a hearing. There's usually one Court of Appeals judge and 3 district court judges that have a hearing. Then once you get through the hearing, you have to wait until the Judiciary Committee votes, and that can take anywhere from a week to however long they decide. Once they vote you out of committee, assuming that happens, then you have to get marked up on the floor. And that is where a lot of political things go on. There were a number of compromises made to get judges through when I was going through the process, and they would make a deal, and we would get a call that would say, you're going to get confirmed tonight. And I remember one instance, Senator Hutchinson, Kay Bailey Hutchinson, was in a dispute with Senator Bradley and over a bridge. And so Senator Bradley had one of the people in the group that was going through at the same time I was, and so she put a hold on the judges because she wanted to negotiate about the bridge. So it's a very, very political process now, and I guess 2 things about it is it seems to work. And the other thing is that when I clerked for Judge Batten, and he was the first nominee that President Nixon had when President Nixon was elected as president. And he was nominated by the president, I think, like on February 21st, and he was confirmed on February 25th. Rusty Smith, Senator Mansfield said he's going to be the judge, and a week later he was. So that part of the thing has changed considerably. There is a different way of selecting the magistrate judges and the bankruptcy judges. We've just gone through a magistrate selection process, and the magistrate judge, unlike the Article 3 judges, has their jurisdiction is all statutory, and they get that from the Congress. What happens is we have a committee of lawyers and lay people who are appointed. Judge Haddon appoints some people, I do, and Judge Siebel. We're the 3 active Article 3 judges in Montana. And then the chair of the committee, it's been one of the justices of the Montana Supreme Court the last 2 times that we've done it, Justice Cotter and then Justice Regnier. And they meet, and it's open to anybody who would like to hold the position. And they interview, look at background information, and then they make a selection of 5 names. They submit that to the 3 active Article 3 judges in our state, and then the 3 of us meet, and it's by majority vote of the active Article 3 judges that the magistrate is selected. We have a bankruptcy judge, actually there are 2, Jack Peterson, who is the longest sitting bankruptcy judge in the history of the United States, is in Butte. And he's a senior recalled bankruptcy judge, and then we have Ralph Kirscher. And the way they are selected is that there again is a committee put together, but it's the Ninth Circuit Court of Appeals that actually selects who the bankruptcy judge is. It's not the district court judges. Gladys had asked, well, how do you get selected? And I think the answer to that is it's like trying to figure out, how do you get struck by lightning? It's really, Judge Goodwin, who is on the Ninth Circuit, a wonderful man, he says that every morning he gets up and when he shaves, he says it's good to be alive, and he's really glad that he has a senator that's a friend. And it's a political thing in a way. When Judge Thomas, who's our judge on the Ninth Circuit, and when I got selected, it was the only time where they actually formed a committee of people from around the state and then opened it up to anybody who wanted to put their name in. So it was kind of a merit selection, although merit is I don't want to overstress the merit part of that. They did have a committee, and they came up with 3 names, and then Senator Baucus, in consultation with Senator Burns, picked a name. So how you get selected is really how do you get struck by lightning. The kinds of things that the federal judiciary is involved in, we have 2 different kinds of cases, criminal cases and civil cases. The jurisdiction over the civil cases comes from the 7th Amendment of the Constitution, and when the Constitution was enacted, if there was a dispute between citizens of different states that involved at least $20, then you could bring the suit in the federal court. Over the years, that's gone from $20 to all the way up now, it's up to $75,000. So any dispute between citizens of different states that involves $75,000 or more, there's a subject matter jurisdiction. The criminal jurisdiction, it seems as if the Congress enacts more and more and more criminal statutes all the time. I have a great sense of appreciation of federalism, and I believe that our state judges, our state Supreme Court, our state law enforcement agencies have the skills and abilities to deal with a lot of the criminal stuff, but because there are what's called dual sovereignties, the state and the federal, the same crime in Judge McLean's court, that he could have somebody that pleads guilty over there, and then they could be indicted in the federal court on the same facts and come over and plead guilty and get sentences from both judges that wouldn't necessarily run simultaneously. So we have jurisdiction over a lot of criminal cases. There appear to be now a lot of cases involving guns and drugs, pornography, drugs, and then illegal aliens. We seem to have, for the state, quite a few of those kinds of cases. It's a fascinating job. I'm not going to go into a lot of detail, but there are issues that when we get a really hard issue, we can ask Justice Rice and his colleagues to answer the question for us. And we have a process where we can work with the state Supreme Court to certify controlling issues of law under Montana law to the state, and then the Montana Supreme Court will answer those questions. I know right now that they have a very significant issue, I believe, on the state constitution and its applicability on the clean and healthful environment. And then I think the Ninth Circuit just certified a case, a personal injury case out of a snowmobile that I had tried, and it went on appeal, and then the Ninth Circuit Court of Appeals asked the Montana Supreme Court what's the right answer. So does that cover the background? I probably used up way more than my 15 minutes.
You're just right on.
All right, Justice Rice.
We'll pass it on to Justice Rice.
Thank you, Judge Malloy. Is this microphone close enough to? All right. Well, good evening, everyone. I want to thank the League for their invitation and for sponsoring this event, and thank all of you for giving up an evening of your time to participate in your democracy. I appreciate that very much. Our assignment tonight is to explain from our respective perspectives the qualifications and the process of selection, how we arrived in this position and how we have come to do this job, and also talk about our judicial authority and the limitations on that authority. And I think probably the purpose or the question that is being set up by that discussion is the proper role of the judiciary in our democracy. There's been quite a lot of controversy about that issue over the last several years, both state and federal, and it certainly is a timely question here in the state of Montana, where there are currently 3 citizen initiatives for which petitions are being circulated throughout the state of Montana, asking citizens to sign to put these initiatives on the ballot that would somehow affect or limit judicial authority of our judges in the state of Montana. And I won't get into those right now. I do have definite opinions about all 3 of them, but perhaps later in the night we can talk about them, or you may have a question about them. But in any event, I think it certainly demonstrates that this issue of authority and what the proper role of at least the state courts in our democracy is a very timely issue. Of course, the process of selection of judges in the state of Montana differs significantly from the process that Judge Malloy just described to you on the federal level. I think one of the questions I get most often when I'm talking about this subject, well, which system do you like the best and which is more political? And I think maybe you will conclude by the end of the evening that politics pervades in either one of those systems, and there's certainly not any one system you can adopt that will eliminate the politics from the process. First of all, qualifications for a Supreme Court justice in Montana, actually, from the technical point of view, the technical legal qualifications are very minimal. They are set by the Montana Constitution. You have to be a United States citizen who has resided in Montana for a period of 2 years. You have had to been admitted to the practice of law in the state of Montana for a period of 5 years. And that's all. So I guess unlike the federal system in the state of Montana, you do have to be a licensed attorney to be a judge, which, as Judge Malloy described, is not necessarily true in the United States Supreme Court. But that is a legal qualification to be a justice in the Montana Supreme Court. But as you can see, those qualifications I've just described are really fairly minimal. When you think about selection of a judge, you tend to think it's somebody who has more than 5 years of legal experience and has been in Montana for more than 2 years. I would say that all those other things that we think about going into being a qualified judge, I think the voters certainly consider them to be qualifications and certainly look to people who have more than 5 years experience or have been more than 2 years when they make their selections at the voting booth. But those are not legal selections. Or legal qualifications, rather. I guess the big difference between the state and the federal governments is in Montana we do elect our judges, generally speaking. We do have an appointment process in Montana as well for those situations where a vacancy occurs in a term, a judicial term, between elections. In fact, 4 of the 7 justices who certainly currently serve on the Montana Supreme Court came to the court by appointment and then had to run for re-election after initially being appointed. The other 3 were first elected, although at least one of the other 3 attempted to gain a position on the court by appointment first. So you can see that even though the default mechanism for selection of judges is election at the Montana Supreme Court, the appointment process is used quite frequently, and I will talk about that in just a moment. But first of all, elections. Supreme Court justices run statewide campaigns for election, just like our other statewide elected executive branch officials. We run statewide. I think recent campaign, last time I put 59,000 miles on my car traveling around the state of Montana and attended just about every fair, festival, and fish fry within the state of Montana during the course of that campaign. I think my father, who's not with me tonight but usually travels with me, he keeps the statistics of everywhere we go, and I think he recorded last campaign we were in 46 parades, and that's a lot of parades, let me tell you. So judicial candidates for office run a statewide campaign, much like the other statewide officials do. However, we run on nonpartisan ballots. And I really think that is a blessing for the state of Montana that we don't have judges running on party ballots. We don't run on issues. We don't run on political platforms and take positions. And I think it would be very unfortunate. And this has happened a time or two, and I think it's unfortunate when it does, when a judge will campaign on a particular issue, because I think it takes away that judge's impartiality when that particular issue comes before him. And if I were a litigant coming before a judge and perhaps I was charged with DUI, for example, I hope I would not be charged with DUI, but in the event that I would be, I certainly would be hesitant about having to appear before a judge who had ran a strong anti-DUI campaign for election. And that's the reason that most judicial candidates try to stay away from taking positions on issues, announcing platforms that they will rule a certain way or another, because I think it robs them of their impartiality. The nonpartisan ballot is an irritant to some people, especially those who are connected closely with one party or another. Activist party people really appreciate the party labels, and they would like to be able to kind of figure out who the best person is, because when you have several nonpartisan candidates and no party label to identify with, and you don't run on a platform, sometimes it becomes pretty tough to figure out who to vote for. I mean, how do you tell one from the other? And I would say that judicial candidates take a little bit more digging to figure out really what they're all about. Maybe it takes a little bit of reading maybe some of their decisions, or asking people or lawyers about what kind of judge they have been and what attitude they have on the bench, and what's their approach to judicial decision making, and what's their general philosophy. It becomes a discussion about those sorts of things. And too often, especially in the media, it's just too simple for reporters and others to say, well, she's liberal and he's conservative, or, you know, she doesn't legislate from the bench, but he does. And it was sort of, these terms kind of float around, and I think probably oversimplify the judicial candidate, but that's sort of what people resort to because of the nonpartisan ballots and the non-political nature of the campaigns. As I mentioned, we do have an appointment process in Montana when the vacancy occurs in the middle of a term. In some sense, it's less political. In other sense, it's probably more political. By that I mean, we have in Montana a judicial nomination commission, and the commission is set up to take applications. They do a sort of background investigation, not near the intensity of the federal level, not even close. But you have to submit, you know, your tax information and, you know, information about you, what businesses you've been a part of, what cases that you have litigated, and that sort of thing. And then they interview the candidates, and then the commission submits a list of names to the governor. And the governor has to appoint one of the people on the list. The governor doesn't have the authority to say, well, I don't like those people. They've submitted to me 3 conservatives, and I'm a liberal, and I want someone else. The governor has to choose one person on the list. So in that sense, the executive power in the state of Montana is much less than the president's power on the federal level. And we certainly don't have the shenanigans that go on in the legislative process. I'm sorry, maybe shenanigans isn't the right word. Maneuvering, maybe that's a better word, that we have at the federal system. The legislature here is very deferential to the appointments of the governor. I don't know, I can't remember when a legislature has refused to confirm a governor's appointee. I was very fortunate to get a unanimous vote of all Republicans and Democrats when I was confirmed. It's probably no secret that it was helped the fact that I had served in the legislature and knew all those people, but and not all candidates have that luxury. But it's not political in the same sense that appointments at the federal level are. Let me briefly, in the last section of my comments, talk about our authority at the Montana Supreme Court. We are an appellate court. Most cases that come to us, we are exercising an appellate function, reviewing a case that has already gone through the process at the district court or trial level. And so we have original jurisdiction, or that is power to entertain cases that start at the Montana Supreme Court for a very few or very narrow kind of case. But most often we are reviewing cases that come by way of appeal. There's always been already been a decision at the district court level. There's been a winner and a loser. The loser's not happy about it. They want to appeal and have that decision looked at. The Montana Supreme Court is the only appellate court for the state of Montana. Unlike the federal system that has the circuit courts or an intermediate level of appellate court between the trial court and the Supreme Court, we don't have that intermediate level here. We have to take all appeals that come to the Montana Supreme Court. We have no authority to turn them down. So that is what we end up doing most of the time, is appealing or reviewing on appeal a decision made at the district court level. The limits of the authority that we have, I would suggest are the limits we normally think of in terms of the separation of powers and the checks and balances between the branches. I guess I bring a perspective to the court of having served in the legislature. That body was composed of 150 people representing every geographical area across the state of Montana, every kind of educational background in the state of Montana, different occupations, different ages. There have been people elected to the Montana legislature that both teenagers have been elected. We've had octogenarians that have been elected. When you serve in the legislature, you're privileged to really expose yourself to a wide variety of different kinds of people and different backgrounds that come together to make the laws for the state of Montana. I respect that process very much. If you contrast that to the group of people I serve with now, well, we're all 50-something. We all had the same education. We all had the same employment experiences. We're all lawyers. We all come from essentially the same socioeconomic group across the state of Montana. And so in contrast to the legislative branch, there's very little diversity. And really, we're not elected to bring kind of diversity for purposes of making the law. We're elected because we have a specialty, that we are experts in a science, and that science is the interpretation and the application of the laws passed by the legislature. And we try very hard to stick to our role and apply the law that the legislature gives us and that the people gives us, either through the Constitution or through the initiative process, and not get in the way of the process and debate on policy issues. I think when Chief Justice Roberts was confirmed this last year, he used the sports analogy when describing the judge's role. In other words, if you watch a football game, you got those guys out there in the black and white shirts, blowing the whistles and calling the rules. And our job as judges is not to advance the ball in society one way or the other, or to the left or to the right. That's someone else's job. We're just there to make sure if they go out of bounds in their effort to get the ball down, the whistle blows and said, you've gone too far, you crossed the line, go back in fair play and advance the ball in a fair way. And that, in a nutshell, is probably our authority and the limits that's on it.
Thank you. Judge McLean from the Montana District Court.
Thank you. And again, thank you for having me before you this evening. I appreciate the opportunity to address you. The qualifications for a district judge are the same as those of a member of the Montana Supreme Court, with the exception that there's an additional qualification that we have to reside within the judicial district that we are serving. And in the case of Missoula, that would be Missoula and Mineral County, the 4th Judicial District. At one time, it comprised of 5 counties: Lake and Sanders, Ravalli, Missoula, and Mineral. And then Lake and Sanders County were cut off to form the 20th Judicial District, I believe. And then Ravalli County was split off to form the 21st. The vast majority of your district judges assume the bench, I think, by way of appointment, and then have to stand for election at the first general election after the appointment. It used to be that when the governor appointed, you did not need to run for re-election until after the legislature convened and the Senate voted to confirm or not to confirm you. Now the rule has changed that you stand for election at the first general election after the appointment. In my case, I was appointed on December 22nd, 1988 by then Governor Ted Schwinden. And on the 1st of January, Governor Schwinden left office, as did the Democratic majority in the Senate, and Governor Stevens come in along with a Republican Senate, and I developed what is commonly called the case of the sweats. I received a call from Governor Stevens to go over and visit with him. And when I went over, I was surprised at the amount of time he took for the interview, because I really thought things were going to go south on me. And he spent about an hour and a half, and when we had finished, he told me that he would not only not stand in my way, but he would ask the Senate to confirm me. And at that time, we had Fred Van Valkenburg and Mike Halligan were Democratic senators from Missoula. And they talked to their Democratic colleagues, and Bruce Crippen was the head of the Senate Judiciary Committee. And how they did it, I don't know, but they got me through the Senate confirmation process without any nay votes. And then immediately we start standing for election. And I have been fortunate in the terms that I have run that I have not had any opposition. And it's been the experience throughout Montana that it is not very usual for a district judge to have opposition if the judge is taking care of his or her business. You do see it on occasion. Right now, of all the district judge races that are going on across the state of Montana, and this is one of the years where the majority of our seats are up, I'm only aware of 2 contested elections involving a sitting judge. And there may be more. I know that there are some contested ones. Department 2 has 5 candidates going for it in Missoula. Judge Meisner's not running for election in the 3rd Judicial District. There are 2 candidates running for that. Judge Whalen is not running in the 2nd Judicial District in Butte, and I believe there are 4 candidates for that. So when a seat is open, there's plenty of contenders, but if you're an incumbent, as a general rule, you're pretty fortunate if they don't have any colored photos of you doing something inappropriate. I think that in Montana, where we addressed some things back in the 1971, 1972, there was great talk about what we're going to do in our new Constitution. Are we going to have a unified bench or not? And by unified bench, what was being addressed is, are we going to have everything be a court of record, or are we going to continue on to where we have district courts and justice of the peace courts, and then courts of limited jurisdiction? And the overwhelming discussion in the legislature and in the legislative notes indicated that they did not want to do away with justice courts. Those were courts of the people. And what we were addressing back at that time was whether or not we should have magistrate courts to assist the district courts. And the fear was that if we got into magistrate courts, which you have to be an attorney, and it's pretty much the same qualifications as a district judge, if we have a magistrate court, are we then going to step down and start assuming duties that are now performed by justice of the peace courts and start usurping that court? And the legislature did not want to trample on what they called the people's courts. So they refused to authorize the magistrate court. But they did leave the legislature out for creating standing masters or special masters if they saw the need. At the present time in Missoula, we have 2 standing masters, and I can only address one of them, and that is Susan Leapart, who works with me. When I became a judge in 1989, it took over 2 years to have a contested divorce heard. And the question is not how tough it is to break up an estate. That's the simple part of the tough part is how do you take a child of a broken marriage and try and rescue that child from the havoc that is about to ensue. And as a general rule, if it takes you 2 years to get to trial in a district court level, you then have another couple of years to go through the appellate process. You got a child who's in the 1st grade, and all of a sudden that child is in the 5th or 6th grade with a chip on his or her shoulder that we're not going to remove. My concern at that time is, what do we do for the children? We created the Standing Master Court, and it now takes approximately 6 months to get a contested matter heard as far as a divorce. The parties can always disqualify the standing master where the matter comes back to the district judge. Where I find that the standing master gets disqualified is not on the family matters, but if there's a substantial estate, then the parties want to move as close to the Supreme Court as they can get. So instead of starting out the standing master, then going to the district court, they'll start at the district court and then go on. Those cases will take a while, and those cases do not concern me. We can wait to divide up the estate. There's not a great rush, but when it comes time for our children, we have to figure out how we're going to do things as quickly as possible. And when Susan gets through with the matter, then what I do is, if someone has an objection to the standing master's findings, they have to raise particular objections. I agree with finding 13 or finding 14, and then the district court will have a hearing, but only concerning the objections, not everything. Then we get a ruling out right away and send that matter on. So hopefully we have the child under a parenting plan, you know, within 6 to 8 months after the original petition is filed. And that is something that at the present time is rather unique to Missoula as far as domestic relations, but is being discussed a lot statewide. And it's being discussed in what can we do on the domestic relations side to keep from expanding our judiciary, the numbers of district court judges, into different arenas if we can do it on a more limited basis. Now, we've got committees that talk and discuss where we're going with that, but that's where we're at in our state of the judiciary in Missoula as far as how we're trying to address the problems that are creeping up most. We do see a lot of problems where the same defendants are in district court in the state and in federal district court in front of Judge Malloy. And we have people come in and they'll ask us to relinquish jurisdiction to the feds. They have the mandatory sentencing when it comes to certain types of drugs and certain types of weapon offenses. And that gets discussed more at the prosecution level than anywhere else. And the prosecutors and defense counsel have their discussions, and then the matter comes up to our court asking us to relinquish jurisdiction to the federal court. And it's very seldom that you ever see the feds asking the district judge to send it back to the states. They generally want to go up there because of the mandatory sentencing and the more severe financial penalties that are imposed. I think that there was a real change in the relationship of the federal-state judiciary when Don Malloy came onto the bench. At that time, we were back in the backwoods as far as any electronic courtrooms, anything of that nature. Judge Malloy brought an electronic courtroom into the federal building and invited us over, the judges from Missoula, over to look at it. We went over to look at it, and he was so kind to give us the materials on brushing up on electronic courtroom, and not only that, lending us the expertise of his staff on how to set one up. And we brought one into Missoula County and are in the process of making plans for a second one. The other thing upon Judge Malloy coming in is we only had 3 courtrooms at the time, only 2 of them were for jury. Is he immediately extended an invitation to us to have access to the federal courtroom so we could utilize that if we had conflicts in trying to schedule juries. And I think that in Montana at the present time, you see a great cooperation between the feds and the state, and it tends to be one-sided as the feds have the resources and we have the begging ability. But it's been a good relationship, and it's been a cooperative relationship.
Thank you, Judge McLean. And Judge Orzik from the Missoula Justice Court.
Thank you for having me here tonight. It's really an honor to be here and to talk to a room of people who are not my defendants, okay? And I'm enjoying that immensely. And plus, I'm learning a lot about the judiciary that I did not know. I'm a member of the courts of limited jurisdiction, and the courts of limited jurisdiction are just that, limited. They are the city courts, the municipal courts, and the justice courts across the state of Montana. There are 109 of us, and we're all meeting this week at the Holiday Inn for our training. We go to training twice a year, and this week is our training. There are jurisdictionally, these courts get their authority from different sources, like the authority of the Justice Court is constitutional, the authority of the city courts and the municipal courts are statutory. The justices of the peace are elected. Some city court judges are elected and others are appointed. It depends on the city. My jurisdiction is listed in a list of 7 things of which I can do. And basically, everybody knows the justice of the peace does what? Weddings, okay, lots of weddings. I do about 135 a year. And I have to say, if I didn't do the weddings, I wouldn't do the rest of it, because the weddings lend a lot of balance to the rest of my job. The other limited jurisdiction that we have are orders of protection, protective orders that we issue in cases of domestic violence, rape, homicide, stalking, things of this nature. We do small claims cases up to $3,000. And small claims cases can be very interesting, like who owns this horse? Is it the person who has the title? Or is it the person who fed the horse and brought the horses to the races and cleaned the stables and such? These are the cases that I hear, the People's Court. I hear cases where people stop talking to each other and they decide to file. And the first thing that I tell them is you must mediate. And if you don't, the penalties are pretty severe. If you're the plaintiff and you don't show up to mediation, your case is dismissed with prejudice, which means it just goes away. If you're the defendant and you don't show up, well, the plaintiff gets everything they asked for. And so these people are given the opportunity, you are given the opportunity to solve your own problem before you really want to put it in my hands, because I'm going to look at the facts and I'm going to apply the law to the facts and I'm going to come up with a decision that either one or both of you will not be happy with. So maybe you can mediate this. And this is a good thing because we get thousands of civil cases. I'm moving on to the civil cases, not the small claims. The civil cases go up to $7,000. So these thousands of civil cases many of them are check collection, and there's never any answer filed, and so there's a default judgment given, and a lot of it is paperwork to get these thousands of cases through the system. But a lot of it, much of it, is providing the opportunity for people to solve their problems. And if they can't, well, I provide the opportunity for me to solve the problem in a trial. I do a lot of criminal cases. Felony and misdemeanors are different. My role is very, very different. And what you read about me in the paper with setting bail is just a very small part of what I do. On a felony, I read the rights, I tell people what they're charged with, I set bail, I appoint an attorney. Okay? And then the defendant says, okay. And when I do that, I'm reminding myself of exactly what I'm doing as a judge during that moment of time. Okay, these are the 4 things that I'm doing today for you, and this is all that we're doing today. Then the felony goes up to one of the district court judges to be resolved. might come back down with a plea agreement on a misdemeanor, and then I'll take care of sentencing there. On a misdemeanor, I do those same things and then take a plea. It's either guilty or not guilty, then do a sentence, which I believe is one of the most important things that I do as a judge, is to come up with an effective sentence that's going to somehow change behavior. And Judge McLean was very diplomatic when he talked about the people that we see again and again. These people are frequent flyers, okay? And they come to court a lot. And oftentimes, they are caught up in the system. They're caught up with poverty, drugs, alcohol, violence in the family. And again, I provide the opportunity for people to take advantage and change the way they're living, or if they decide not to take that step, then we have the carrot and we have the stick. That's basically what I do in court all day long, every other afternoon. My jurisdiction is Missoula County. Don't go outside the county. Can go outside the county for service within the state of Montana. My job is to listen, to be fair, and to make good decisions, and hopefully to solve problems in the community before they get up to Judge McLean. I serve on the Supreme Court Commission on Ethics, and we're looking at the canons of judicial ethics, and they are a collection of a list of what a judge should and should not do. And we are the last state in the union to have canons of judicial ethics, the very last. And we are looking at going to a code of judicial conduct, which basically changes what a judge should do to what a judge shall do. And legally, they're very different from each other. You shall do this, you will do this. And at this time, the canons or the Code of Judicial Conduct is being reviewed by the Bar Association nationally. And then once they get it into a better form that we can work on, we're going to look at it for the state of Montana, because of course Montana is a little bit different than the rest of the nation. Okay. What else do I want to talk about? Oh, I do jury trials, non-jury trials. I talked about civil cases, criminal cases. The longest jail time I can impose is 1 year and a $1,000 fine. We do a lot of the ACT program, which is alcohol counseling, education and treatment. A lot of counseling with a focus on anger, dangerousness, chemical dependency, and violence for those that are involved in assaults and partner family member assaults. It's a lot of different things. As for qualifications for justice of the peace, anyone can run for election. Anyone. You got to be a resident in the county. And then once you're elected, you go to judicial training twice a year. And I'm the training judge for Western Montana, so the judges up and down this edge of the state. I've been fortunate enough to visit Libby and Kalispell and down in Darby, etc., Hamilton. And it's been I've been honored to do that, and I really enjoy that. We have judges that 80% of our judges are not attorneys in the courts of limited jurisdiction, 80% of us. And most of them, well, we come from a variety of backgrounds. There are former prosecutors, former law enforcement, former criminal defense attorneys, former nurses, farmers, ranchers. There are part-time judges that only work 3 hours a week. There are judges like Judge Odlin and myself who work more than 40 hours a week and every other weekend. We come from the whole variety of different backgrounds, and I think that's our strength right there. Our strength is there to serve the people and to listen and do it in a fair manner. That's why we're there. Okay.
Grab this one. And is it on now? Why don't you just take a few minutes and stand up and stretch and do a couple of deep knee bends or whatever you need, and then we'll get back to a few questions. So I'd like to start back down there on the end with Judge Orzik. And this is a question about elections. You are the person who must run most often and in the smallest jurisdiction. Would you talk a little bit about how you feel running for an election influences or does not influence whatever your management of your court, and allows you to be either independent or affects how you manage? That was kind of a garbled question, but how does that need to run for election affect your management of your court?
It shouldn't, and it doesn't. I think it's important to be honest with yourself. I mean, I'm the one that has to wake up each morning and look at myself and decide if I'm doing the right thing. I think running for an election and putting the matter out to the voters to decide who they're going to have as their justice of the peace is fine with me. I like it because it gives me an opportunity to reflect on what I'm doing and why I'm doing it. It gives me an opportunity to serve the public, and I couldn't ask for a better job except when you're in office and you're running a campaign at the same time, it can be very difficult because they're really two full-time jobs. And as Justice Rice said, the importance of what we do and how we do it, and not to talk about our opinions, you know, our personal opinions about this or that, is very important. And I think we have to look at, as judges, we're there to make decisions on everybody's cases, whether they're Democrats or Republicans or independents or freemen. We're there to preserve rights of everyone that comes before us, whether they're a plaintiff or a defendant. We're there to listen. That's what we're there for. And then to go out and toot your own horn during the election, well, I'm kind of an outgoing person anyhow, so it's not that hard for me, okay? But it's a different role. All of a sudden, you're not listening so much anymore. You're doing a lot of talking. So during the day, you sit, you listen, you pronounce judgments, and then in the evening, you do your electioneering.
Okay. Yes, Judge McLean, do you have anything to add?
Well, I think that we all develop a judicial philosophy as we're putting our time in on the bench, and that judicial philosophy becomes evident to the attorneys, the Bar Association, in the case of district judges. And whether it be a criminal matter or a civil matter, they have a tendency to know, here's what you can expect from Judge McLean, here's what you're going to get from Judge Larson, here's what you're going to get from Judge Harkin, and here's the limits where you can push them on certain issues. And I really believe that the feeling is you see very, very little substitutions in civil matters. You see a few more when it comes to criminal matters, that people will say that McLean has an aversion to certain type of crime. Judge Harkin, Judge Larson may have aversion to other types of crime. And it all tends to balance out. I don't think that you see any one of us getting substituted more than the others, but on particular types of crime. And I think it all goes to judicial philosophy. And I do not believe in my own mind that that is affected one way or another by standing for election. I think that you have a philosophy and you tend to follow that philosophy and you keep cases going. If you decided to stop at each case and say, this is the outcome I would like to see this case achieve, that your court would come to a virtual standstill because you wouldn't have time. You have to run it on a philosophy and according to the rules as you know them best to keep the caseload coming. And when you're cranking out 1,000 cases a year, say you're averaging 3 cases a day, you don't have time to sit and say, here's where I want this case to wind up 6 months down the road or 18 months down the road. You've got to turn those cases over as they're before you. And I don't think standing for election affects that. I think your philosophy as a person and as a member of the bar and how you're getting the workload behind you and you're trying to see justice achieved is what affects you. And it's being consistent all the way through.
Thank you. I'm going to address some of my questions to specific judges, but if any of the others of you have comments to add, please just grab the mic and add some. I want to address this question to Justice Rice. You mentioned that there were a number of constitutional initiatives coming up on the ballot this time. One of them, Constitutional Initiative 98, would provide a process to remove judges from office before their term expires. If that provision were to pass, how would it affect your ability to act impartially in between elections?
Well, I think it would have a chilling effect both upon current judges and worrying about if they were going to lose their job tomorrow because they had to make an unpopular decision. I mean, I think many judges would go ahead and make the unpopular decision, but I think that would give them some reason for concern about what may happen to them in response. And I think it would be very difficult to recruit people to ever run for judge if they had to give up their current employment or their current practice and assume the bench only to be able to be recalled really in the words of the initiative for any reason. That's a pretty low bar to reach, where right now you can recall a judge, but it has to be for some specific reason, some malfeasance in office. This would lower the bar, and just if people didn't like the judicial philosophy maybe that they perceive that you have, or you had to make a decision which was unpopular politically or in the eyes of the community, you could start a petition and say, we don't like this decision that this judge made on bail and letting this guy out on jail, and we want him recalled. And if enough people sign and got it on the ballot, you could be gone. And I just think that's an inappropriate, I guess, check on the judiciary when we have a system in place that if people feel a judge is doing a bad job, we have a scheduled recall. It's called the next election. And if you don't like what the particular judge is doing, you have the opportunity to remove that judge in an orderly fashion. And I think that's the mechanism we should stay with. But of course, I won't take a position on that.
Judge Malloy, you are in the enviable position of not having to run for election, but how do you balance the ideas of independence for the judiciary and accountability for the judiciary? If you don't have to run for election, you don't have to be reappointed or whatever at any juncture. How does the public have any influence or any control, any input on your decision making?
Well, I think the input that they have is through the litigation process, and that is a formal mechanism of where disputes come into court. There's advocates on each side. Each takes a position with respect to the law, and then there's a decision-making process. I think that the issues that we're seeing in South Dakota, which the ballot is on the initiative is on the ballot there. The issues in Montana reflect the wisdom of the Founding Fathers in having an independent judiciary and having lifetime appointments, which probably explains the very, very, very detailed, methodical background investigation of every federal judge, that knowing that this person, he or she is going to be there the rest of his or her life, that you want to make sure that it is a person of reasonable intelligence who who has a judicial disposition and who has an ability to decide things fairly. There are probably roughly 900 federal judges in the country, and we see each other frequently. And the interesting thing to me is that if you read in the press, just like it was with Justice Alito and Chief Justice Roberts, or you talk about Justice Stevens, he's the liberal, or Justice O'Connor was the swing vote, or Justice Kennedy's the new swing vote, I think that's a lot of malarkey. My experience is, whether it's a state judge or the federal judges, every judge takes his or her job extremely seriously, and they try and arrive at a decision within their intellectual understanding of the law. Now, obviously, not everybody's going to arrive at the same answer, but I think that the system works, and the public really doesn't have any input after the process. Once you're confirmed by the Senate and that commission is signed by the President, then it is a lifetime job. And I had a friend who is in the banking business, and when I was nominated and confirmed, he called me and he said, "You know the three most powerful people in the world?" And I said, "No, I don't." He said, "It's a Navy captain at sea, a Marine drill instructor, and a federal district court judge." And he was being funny, but he wasn't being funny. And so the enormity of the office, you have to constantly remind yourself that it's not, as Justice Rice says, what I think is right or wrong. It has to happen. Decisions have to be made within the context of the adversarial system and the law as duly enacted by the legislatures or the Congress. So I don't have, I mean, I read the paper like everybody else, and I see, you know, one day I'm the best guy in the world, and the next day I'm the worst guy in the world. So that's just the way it works. And I think that the issue of judicial independence is particularly in the state courts, is really being threatened right now. In Ohio this year, for the Supreme Court in Ohio, they spent over $10 million on an election. Now, Mr. Harrison's dad was on the Montana Supreme Court for years, Justice Harrison, and he told me one time that he never spent more than $4,500 for a campaign that he ran covering the 59,000 miles. And Justice Rice, Judge McLean, they can tell us how much it costs even in Montana now. And when you're raising hundreds of thousands or millions of dollars, I mean, I think it's a threat to the independence of the judiciary. And this kind of stuff that this initiative, like they have in South Dakota, is these kinds of forums. There aren't enough people that go to them to get a grasp of what the courts are really about.
Could I make a quick response here? You know, when we talk about the appointment versus the elected judges, and there's some room for debate there. But what we have to remember is when they made the lifetime appointments in the federal system, that had it not been for the lifetime appointments, that we wouldn't have the justice system that we know in America today. When John Marshall first started protecting some constitutional rights of people and of concepts, you know, certain people like Andrew Jackson went to an early grave with strokes and hemorrhages, wondering how they were going to stop him. And that famous quote is, well, we've seen what John Marshall wants to do. Now let's see how he does it, refusing to use the executive to enforce the judicial decree. And it was the first monumental constitutional crisis we had. And without lifetime appointments, quite honestly, our judicial system would not have maintained or survived in those early years. As to whether it should be an elected or appointed is the pressures, I think, to go after an independent judiciary are enormous. And sometimes we see it turn into a political war, sometimes we don't. I notice that Justice Rice and Justice Warner are unopposed. When I had occasion to run for the Supreme Court 2 years ago, I ran against an individual by the name of Brian Morse, and he's a top quality guy, and it was an expensive but a very cordial race. It turned out to Brian's liking and not so much to my liking. But it was an educational experience for the two of us, and it wasn't a name-calling, backbiting contest. On the other hand, the other race that was going on at the same time, it was an embarrassment somewhat to us all to see how contentious and derogatory it became. And when you look at that, it makes all of us wonder, should it be an elected or should it be appointed? I like the idea that the people of the 4th Judicial District are going to have a say in who their judges are going to be. At the same time, I'm very well aware that on the federal level, we wouldn't even have the system survive. And if the federal level didn't make it, we certainly wouldn't have the state levels emulated. So I think that we needed them both, and I think we still need them both. And there's pros and cons to each.
Thanks, Judge McLean. Just let me note, the league has been interested in electing judges and how we do that for some time. And if you didn't pick up one of these little bookmark-shaped things, pick one up, because there are some interesting comments about what to look for when you select a judicial candidate, and what to look for in a judge. So grab one. Are there questions from the audience? Sir, we want to...
I just have a short question. Is there any state that elects its judges on a partisan basis? There are.
Yes.
Minnesota just had a Supreme Court, United States Supreme Court case. I think it's...
We're going to need to pass the mic on so we can
mic,
be
sorry.
sure to...
I'm embarrassed that I don't know the name of the case. Justice Rice can probably tell me. I always call it Kelly, the Republican Party of Minnesota versus Kelly, but what is it? White, all right. But in that case, Justice Scalia wrote an opinion, and the issue was the canons of ethics that Judge Orsuch was talking about. The judges are not supposed to comment on cases that could come before them, and that was challenged under the First Amendment, and the United States Supreme Court went all the way up there, and they said you can't put a bridle on what they can say. The reasoning seems to be, well, they can comment any way they want. Once they become judges, then they'll, put the blinders on and be fair. So, but that is the law, that the First Amendment, you cannot inhibit what judges say during the course of an election. It's very interesting. That proposition doesn't seem to work when they're sitting up there being examined by the Senate Judiciary Committee. They can't answer anything because they might have to rule on it.
Each of you have a different judicial venue, and I'm hoping that you'll respond to this and sort of explain from your venue your perspective. But we've been hearing an awful lot about the methamphetamine epidemic in Montana and the rest of the country. And I'm just wondering, are you seeing that impact what's coming before you? And are these drug cases different from drug cases that have come before you with previous drug problems?
Well, let me address the issue from the federal side of things. The answer to your question is yes, there is an epidemic. We have a lot of trials over people who are selling and using methamphetamine. And when you select the jury, there's the questioning process. You'll have 28 people sitting there, and then the lawyers and the judges ask questions. Roughly half to a little bit more than half of the jurors have somebody in their family who's been involved with the methamphetamine problem. And then when you, I don't know what Judge McLean's practice is, but after a trial, I always go in and thank the jurors personally and answer questions not about the case. And they all react the way I have reacted. I've been doing this 10 years. And I keep thinking, well, there can't be anything else. And every time we have a trial, every time I take somebody's plea of guilty, there is something that just, I can't believe I'm as naive as I am. And it is an epidemic. And the drug is far worse, according to those who use it, from any other drug you can get involved in. The first hit, the first high, is the one they spend the rest of their life dreaming about because they can't ever get it back. The physiological impact that it has. I've been on 10 years now, and I am seeing the second generation of people. And I sentenced there was a trial in Butte last week, 59-year-old male, and this was his fourth or fifth conviction on drugs, but he was giving methamphetamine to 15-year-old girls in the high school system. 2 weeks before that, sentenced a 58-year-old man who had been in the federal penitentiary, and he had been responsible for bringing 42 pounds of methamphetamine into Butte. And the street value of that, it's hard to calculate. And I don't know what the answer is. I see patterns in terms of the sentencing. I mean, it's like a template on your word processing. You just see the same things over and over and over. And I don't know what the answer is, but there is a very, from the federal side of things, very significant problem. We see a lot of it used to be, we just saw the major drug crimes, and I don't mean to demean anything, but the 42 pounds is what we would see. Now we're seeing prosecutions in the federal system where people have a gram or 2 or 3 grams, and those historically have always been left to the states. The reason is, in the federal system, as Judge McLean said, if you get 50 grams, you get an automatic 5 years. 500 grams, an automatic 10 years. And then the third conviction is life. And that's I mean, I'm a monkey when it comes to that because I have nothing to say about it. It doesn't matter what the lawyers do, what they say, what the background is. And I have had to sentence from people who just reached their majority all the way up to grandmothers and grandfathers involved in this stuff. And it's a terrible, terrible problem. I have no answer to it. I know Senator Burns recently put out a letter where I think California, Michigan, New York, and maybe now the federal government is beginning to question whether or not all of these people, if the answer is to lock them up for life. Some have to be, clearly. But users, people who are so addicted that, they're just stuck on this drug, I think they're beginning to question, is spending $25,000 to $43,000 per person per year a good investment when you're locking people up as long as we do? And when I came on the bench, there were roughly 68,000 federal prisoners. Now there are over 230,000. That's in 10 years. And most of them are illegal aliens or drug users. So it's a real problem. I don't know, and every time I talk to jurors, the question is asked, what can we do about it? I don't have the answer other than citizenship is not a passive activity. And I do think at some point in our legislature and in the Congress, we have to have a debate about what is the expectation that we all have as the role of the criminal justice system. Is it just to punish? And if it is, are we willing to pay the cost?
You know, at the state level, what our studies have indicated on your teenagers, 84% of your teenagers still have marijuana as the drug of choice. The drug of addiction is by far methamphetamine. 7, 8 years ago, the two hardest drugs to quit in America, number one was heroin, number two is nicotine. They're not even in the same ballpark as methamphetamine. So how we're going to address them in the future, I don't know on the addiction, but 2 weeks ago I had a young lady in front of me and we had taken her baby away from her, and a good part of that was because of her substance abuse. And the father of the baby was down in Las Vegas, and he was under indictment for conspiracy to sell drugs. I told the young mother that I would release her from custody and that I would do sentencing on April 10th. And so she had about 6 days to go. I let her out of jail on a Tuesday morning. Thursday night, they brought her back into jail. She was using methamphetamine again. It was that addictive, and all she had to do was make it 6 days and she'd have had her baby back. And for us to try and comprehend that the addictive power of that drug is just not possible. And the writings on it just tell you that there's no way you can appreciate the addictive quality of methamphetamine. And I do think that the meth ads that they're running now have the attention of the young people, and they say they're being successful. But it's going to take people far more skilled in the area of addiction than I to know how we're going to eventually address it. I've always had a problem that we are taking the users and incarcerating them and not putting enough effort on getting the people who conspire to distribute the drugs. I've advised our county attorney's office and the public defender's office that when you have someone who is manufacturing drugs for sale, do not bring me a plea bargain that does not call for prison time, because I just simply will not follow it. And I guess that's where we're at the state court level.
I'm in my 8th year as a judge, and every day I see someone on meth. But I don't see them for either methamphetamine possession or distribution. I'm seeing them because they have 6 driving while suspended, or they have careless driving or reckless driving or DUI. And they're younger. And my last case was just last week. The kids are 4 and 7. She went on a meth binge for 2 years and left her husband in Great Falls. The husband in Great Falls lives with multiple family members, and brother just was arrested for methamphetamine possession. They live with the kids. She went over to pick the kids up because 42 of the last 90 days she's been in jail, but then she's been clean for just over a month, but he's doing the meth anyway. And it's terrible because she went and got the kids that are 4 and 7, and then he came back to Missoula and got the kids and hid them in Great Falls. And then you get the Department of Family Services involved, and it's very, very ugly. And neither one is, I don't make decisions when it comes to who remains a parent or not, but neither one of them is fit. And what do you do with the kids of this whole generation that grow up in environments like this? I was talking to a teacher who teaches north of us. She has a kindergarten class of 10 students, kindergarten, and 8 of them are showing signs of methamphetamine, being in a methamphetamine environment. 8 of the 10, okay? And what are we doing with our children here? Do we have to have a whole generation of termination of parental rights? I guess the question that I have as a judge is, it's to step back from that and ask the question, why are they doing it to begin with? Is that people aren't happy. They're not. And There are a lot of families that we see that are involved with family violence, and we need to get at root causes. And the justice system or the legal system addresses an event, okay? And it's the social system that addresses the whole family and such. And there needs to be a coming together of this, and there needs to be some type of community involvement also, because you can lock people up and throw the key away. Well, Judge Malloy can do that, but I certainly can't do that. And what happens is they come out, and are they any better? How do you solve that problem? And I don't think you can do it, just with the justices. You just can't leave these problems on the doors of justice and say, fix it. It doesn't work that way. You have to have the community involved.
I just wonder if each of the judges could kind of give us a little breakdown in terms of their caseload, civil and criminal. I mean, it always amazed me. I used to know all those numbers, but in terms of all the cases everybody's handling up there.
Well, let me just start with the federal system. There are about 350,000 criminal and civil cases filed in the United States each year in the federal court alone, which is a court of limited jurisdiction, by the way. There are about 68,000 appeals to the courts of appeal. There in the United States Supreme Court, as you know, they decide about 80 cases a year. So you go from 350,000 to 80. The Ninth Circuit Court of Appeals handles about 14,000, just about 25% of all of the appeals in the courts of appeals in the federal system. With 3 judges here in Montana, in active Article 3 judges, we each have somewhere around a combination of criminal and civil, about 480 cases. We, as a state, run somewhere in the neighborhood of 1,150 to 1,300 cases annually. Those are dispersed, and then the magistrates participate in that. Most of the cases are civil cases in terms of raw numbers. However, 80% of my time is spent on criminal matters. It constitutes about 25% of the number of filings and about 80% of the consumption of my time. It's an inverse relationship in terms of the lawyers in the civil system, as you well know. They bring their cases in, we have a preliminary hearing, and then they pretty much manage things. The good lawyers do that, and every once in a while they'll have a problem, or a legal issue. But in the criminal system, it's from the day they are charged, they have to be tried within 70 days. That's the Speedy Trial Act. And that really causes problems with the numbers of cases that we now have. And it's carrying over. When I came on the bench, I could guarantee a trial date to anybody. Now, when people have civil cases, the law requires that the criminal cases take precedence over the civil cases, and so we're always kicking the civil trials out until some other time. The other phenomenon that's beginning, and I know that the Supreme Court and Judge McLean and Judge Orsich probably see this too, but the number of pro se litigants, people who litigate without lawyers, 30% of our cases are pro se litigation. We have 2 lawyers full-time and 1 clerk of court who work full-time just handling pro se litigation. And it's about the same percentage of the Ninth Circuit Court of Appeals. About 35% of what they do is people who are not represented by attorneys. So that's kind of the numbers for the federal side of it.
The Montana Supreme Court receives about roughly, I'll give you just some rounded off numbers, about 800 new case filings per year. Of that number, about 550 to 600 are appeals from the district courts that we talked about earlier. And the remaining cases break down into the various other sorts of responsibilities the court has. Original jurisdiction matters are those cases that can start at the Montana Supreme Court. Professional responsibility matters, the attorney discipline matters that we have to take up. All the writs and the matters that sometimes you hear about, things like writs of habeas corpus from prisoners who think they should be out instead of in. All those matters together add up to be about 800 cases roughly per year that we deal with, and that's a pretty high number for an appellate court. Especially, we're a state that doesn't have an intermediate appellate court, so we have to take all appeals. So we get a wide variety of cases. I tell people that we get everything from the dog bite case to the death penalty case, and about everything in between. There really is no standard of importance you have to meet before you're allowed to appeal your case to the Montana Supreme Court, so we get all appeals. Of our appeals, about 50% of those, or the biggest category of cases, are criminal appeals. And then all the rest of the kinds of matters make up the other 50%.
At the district court level, in the 4th Judicial District, we're running right close to 1,000 cases per judge per year. And I would say it breaks down to 600 civil, 400 criminal. Court-wise, I think you spend maybe 60% of your courtroom time on criminal, 40% on the civil matters. Research-wise, in chambers-wise, I'd say it's 60% civil, 40% criminal. Right now, we have 2 studies going on in Montana. One is the case workload study, and that is we're trying to figure out how much time judges are spending on each particular type of case, and we're keeping timesheets over approximately a 2-month period to do that. The second thing is the uniform case filing method, so that every clerk of court throughout Montana will report cases in exactly the same way, so we can tell the judicial workload that's going on across the state. And then with the case workload system to try and put a weighting average on those type of cases. But I guess we want the same information you do, Ron, and we're trying to figure out how to get it.
$10,000 is a number of cases that go through my court on over a year period. We just got last year full court case management system, so we've got numbers. And there's been about 135 weddings, maybe around 50 orders of protection. And then the other 4,000 or so each are divided over civil and criminal. But again, criminal takes most of the time. A lot of the civil cases are bad check cases that only require a signature. But it is an incredible workload for one judge. But I have 10 clerks, and they are the workhorses of the courthouse. They're the ones who answer the questions, move the papers, get things to me in a timely manner. And if we didn't have a great crew of clerks, we wouldn't be able to do what we do as judges.
My question is twofold, really, and both of the questions I would like to direct to Judge Malloy, if I may. I understand in reading this booklet that that Judge Erickson is retiring in June. One of the questions is, I am interested in knowing if you have an idea of what the time proximity might be in an appointment of a new judge. And the second question is, you have mentioned that the 35% of the federal cases in litigation that are pro se. How many would you think, what percentage-wise, or will be affected by the retirement of Judge Erickson? Mm-hmm. And of those, how many really do get kicked out of court? Thank you. You used the term kicked out. That's why I said kicked out.
Okay.
Thank you.
We've been through the entire process to select Judge Erickson's replacement. And the Administrative Office of the Federal Courts, which operates out of Washington, D.C., has a set of rules, and the committee has met, the judges have met, we've selected the name. We're not supposed to say who that is until after the background investigation has been completed, because it might be embarrassing to him or her, as well as to the press if they came out with a name. Now, the individual is from Butte, so that background investigation is probably important. That's what I said. The way the pro se litigation works is that the two lawyers that staff the pro se litigation, they do it for the entire state. And so they are in Missoula. So as a consequence, all of the pro se litigation comes to the two staff lawyers in Missoula, and then they work on those things and work with the respective magistrate judges. Because of the location of the state prison, and of course Shelby has shifted quite a bit to Great Falls, but Judge Erickson works on a goodly number of the cases. There should not be any impact in terms of how the cases are managed once he leaves, because the new judge is going to keep Judge Erickson's law clerks for continuity purposes for, I think, for a period of time. I'm not entirely sure what it is. And then with the staffing that we have that handle those pro se cases, there really shouldn't be a lot of discontinuity. The last question as to which ones or what percentage, I can't give you a percentage other than in generalities. Most of the pro se litigation doesn't go very far. There's a whole screening process, and Justice Rice mentioned the prisoners in Shelby and in Deer Lodge, and a lot of times, you know, it's a means for people to keep their minds occupied, and they may not like the color of the Band-Aid that somebody gave them, or think they should have got 2 Band-Aids instead of 1, and so you get that kind of thing. There's a process that filters that out. There's a rigorous examination of these things, and they're all handwritten. And some are quite entertaining in the sense of it's hard to figure out what it is there. But the pro se law clerks have developed such an expertise that they bend over backwards to ferret out and give all the benefit to the litigant. If there's even a remote possibility, then it moves to the next stage. And then the Ninth Circuit Court of Appeals, and I don't know about the Montana Supreme Court, but when you have a pro se litigant, there are lots of rules that require the court to help out the litigant, in the sense that if they're making a mistake, you can't just throw them out of court and say you didn't do it right. You have to say, we're dismissing the case because you didn't do this, this, and this. And if you do these 3 or 4 things or whatever, then your case is viable. The criminal things, there is a constitutional right under a case called Ferretta, where an individual defendant has the right under the Constitution, if he or she makes an intelligent waiver of the Sixth Amendment right to counsel, to represent themselves. And we see that. And there are some very intelligent people involved in the criminal justice system, and some of them are defendants. And sometimes they do a fairly good job. They are very attentive to what the rules are. They don't have a legal education. Some of them are very well educated. They generally don't do very well when they try their case by themselves. But I found jurors are they're aware of, you know, this person is representing herself or himself, And I think that jurors take that into account and try and decide the case based on the facts, not the fact that the defendant may have a fool for a client. Mm-hmm. I think that answers your question.
There's a question over here.
To continue in that vein, I guess for all the justices here, in the 2003 legislature, there was a growing concern about access to justice and pro se litigation, and out of that concern grew also the ACLU lawsuit in the criminal actions that they kind of dangled over the state to bring forth a statewide public defender system, and I've been in attendance in these hearings and in these sessions, and I see that there was definitely a growing concern for a statewide public defender system or a way to control that situation, and also to bring access to justice for everybody through the pro se thing. And I was just wondering how you feel as justices in support of the access to justice, the new public defender system, and being able to teach the citizens how to defend themselves, because I know there are some situations where the prevailing attitude is that we as citizens are too stupid to be able to understand what the law is. And I'm just wondering how you guys feel about it, if you feel that this is a good thing for the citizens, that we kind of get a little bit more back in return, and under the circumstances with the public defender system, are you looking forward to dealing with a more assertive defense and more attention to constitutional and due process rights?
I'll just address that briefly. We have a federal defender system. It's a community defender system in Montana. And then under the federal statutes, there's a right to have counsel appointed if you're indigent. And so almost all of the defendants that appear in criminal cases are represented by counsel. I think there are 12 federal defenders in Montana, and then we have a panel of attorneys that agree to take cases and so they get them. Judge Erickson will appoint them in this division of the court. I don't ever hold the idea that people are stupid. That's not my view of any of our citizens, and I think, though, that it's like trying to do an appendectomy on yourself. You might get it done, but it probably is going to be a lot more difficult than if you have a surgeon do it. And there are difficulties with some of the federal defenders in particular. Generically speaking, that's been an issue. What's the quality of the representation? But by and large, I think our federal system works. As far as the state system goes, I will let Justice Rice and Judge McLean.
Well, over the last few years, we've seen more and more of the judicial function being assumed by the state for purposes of efficiency and uniform administration. And one area, as you mentioned, is the public defender system, which used to be basically a county-by-county system that was administered at the local level. The attorneys were appointed locally. There was an ACLU suit that alleged that there was out of this fractured system was producing a lot of I guess, underrepresentation or insufficient representation. And the legislature, in looking at that problem, decided to respond not by litigating with the ACLU, but creating really what is the first in the nation statewide run public defender system that will have a state administrator and will provide training and hire public defenders uniformly across the state to provide those services. And I think people see it as a good thing. You know, it really doesn't help the system if someone charged with a crime receives inadequate representation and is convicted, and then the case has to go back maybe for some sort of a post-conviction hearing or trial where the adequacy of counsel is looked at, and maybe the conviction has to be overturned somewhere down the road. It's better to do it right the first time. And I think that people broadly feel that there's a great potential in the system, and we're looking forward to giving it a try.
I think that you hit on the key words when you said access to justice. And what our responsibility is to make certain that the citizens have access to their courts. Now, in my opinion, that's a long ways from saying that the citizen should represent themselves in a court system. If they do, the odds are highly likely that they're going to wind up on the short end of the stick. You know, that famous quote is Mickey Spillane, you know, the battle does not always go to the strong or the race to the swift, but that's where the smart money is. And when you get into a contest, you better have skilled help. And whether it's in the medical field, in the financial field, or in the legal arena, you need someone skilled. And I think when we have the access to the court system with the pro se people, that it's important to note that if we want an independent judiciary, we better keep the judges away from all litigants, and that includes pro se litigants. The instant the judge starts to open his or her mouth to advise one of the litigants how to proceed, you no longer have a person acting in the judicial capacity. You have them looking out for one of the litigants, and that undermines the whole premise. And that's where I get concerned. As far as our statewide system goes, the jury's out on that, and it's going to be out on that for a few years. I'm greatly concerned about how we're going to meet the needs of speedy trial for the litigants when we have the bureaucracy coming out of Helena to run the system. I've always believed that we're more responsive the more local we keep things. Now we have discussions going on about whether we should have a state district attorney system rather than a county attorney system on handling the criminal matters. And it was brought up to me, and I said to a couple of the prosecutors, you were pushing for the state public defender system. What's the difference? If it's good for one, why shouldn't it be good for the other? And my basic belief is the more local you keep things, the more responsive you keep things. And I might be wrong, and hopefully this state appellates, the state public defender system will help us. And they're doing that not only on the trial level, they're also doing it on the appellate level.
By the way, the Butte legislators got the bureaucracy in Butte on that, not Helena.
That's true. That's true.
The bureaucracy in Butte came to speak to the judges in the courts of limited jurisdiction today, so I have an update. This state's been divided into 11 different districts. They have hired the chief public defender in 9 of those districts. The one in our district is going to be Ed Sheehy. They are going to move the public defender office from across the courthouse down the street. It's going to be where the kitty corner where the health office is, city health there in that building. They're hiring new public defenders. They're going to contract everything out. We talked with a person who he used to be a judge in the courts of limited jurisdiction, and now he is going to be the person that's going to do all the contracting. And he asked us for input today on who our public defenders have been in the past and who we contract out to, et cetera. So we've submitted our list so that they can pull that together. So they're trying to establish these offices locally, but I think it's extraordinarily difficult to do it in a state of our size, especially when you look at the eastern end of Montana, where you have 250 miles between different courts. It's going to be a very difficult process, I believe, and it'll be a real challenge to implement this statewide system. But they're working hard at it, and they came and reported to us. I'm happy to report that.
Thank you. Is that a real short question? Yes. Okay.
I just read an article about the private judges. Would that leave some of the cases. They handle, the congestion. California, Colorado, and Ohio.
Actually, Montana has a statute that you can have pro tem judges, so you could theoretically have private judging on some matters in Montana. Interestingly, federal judges never used to leave the bench. When you got to be 65, you went on what's called senior status, and then you basically kept up your duties, but continued to draw your pay, and the magistrate judges too. There's a organization in California, and it's called JAMS. I don't know what the acronym is for. They do private judging, private mediation, and it isn't going to be for pro se litigants. The cost varies, but it can run up to $10,000 a day for private judging. And so it's an option, but I'm not sure it's an option for most of us. It's very expensive, and it may fill a need. They have courthouses. And the statutes in California allow them to just treat them just like it was a state court judge, or and they proceed, but it's very expensive.
That's a good answer.
Thank you very much for coming. Next week, we'll be talking about independent judiciary and how it fits in with our constitutional provisions and balance of powers. If you don't have one of the little evaluation sheets, it's a real short evaluation of the program. The answers are 1, 2, 3. 1 stands for yes, 2 stands for maybe, sorta, and 3 stands for no. So just draw a circle around it, put them on the table outside the door as you go. And thank you very much to all of our judges who worked with us.